The Supreme Court is poised to take up on April 25th a novel legal question. And that question is whether a former president is immune from federal prosecution for official acts committed while in office. Now, this is a question that arises in the specific context of former President Donald Trump and the case charging him with plotting to overturn the 2020 election. Trump contends that as a former president, he cannot be prosecuted for any of the actions alleged in the indictment because he says they were official acts. Special counsel Jack Smith's team says there's no such thing as absolute immunity for a president, and that the acts that Trump is charged with were acts that he undertook in a private, personal capacity, not in an official capacity. There are multiple different potential outcomes of these arguments. One, and this is seen as probably the most unlikely, is that the Supreme Court agrees with Trump that he enjoys absolute immunity, in which case the criminal case in D.C. would then be dismissed outright. Another option would be that the court fully disagrees with Trump, which would push the case forward to trial in D.C., although that date is uncertain. Another option could be that the court says presidents may, in certain situations, have absolute immunity, but this is not that case because the actions here are not official acts. That decision would also permit the case to go forward. And yet another option would be that the court could say that the judge overseeing the case in Washington needs to decide whether the acts at issues are official acts before the case can move forward. This is a case that was initially supposed to go to trial this past March. It's been effectively frozen pending the appeal. So depending on how long the court takes on this opinion, it's really not clear whether this case can even reach trial before the November election.